wreck. It just got continued as a result of some recent fighting between the uh, defense team and the district attorneys regarding some of the issues. I guess you saw that too, didn't you,
I
Travis?
did, and according to the article I read, it sounded like the defense wanted to subpoena a witness from out of state, from a federal laboratory, to come testify about test results from blood samples taken from the driver accused of causing the accident.
Right, Benjamin Brewer. As I understand it, the blood samples were sent to two separate labs, one of which is state run and the other is federally run, and they came back with separate results. And that's always the question.
Certainly, it is. I do question. I do wonder of, I guess, the significance of that. I think both test results came back positive for methamphetamine, just a different present in the blood. So it may be that they have an argument that the level of methamphetamine in his blood wasn't as high as the state lab result indicated, but are probably still stuck with the fact that the driver did have methamphetamine in his system at the time of the accident.
Right. He was high, just not that high.
Correct. Right. I don't know how good of a defense that is, but that's sounded like what they were arguing about.
Well, I guess, but once you can show a disparity, then that sort of gives you the crack to start trying to put a wedge in the state's case and start arguing, well, this isn't reliable and credible, then how much else is not reliable and credible?
Well, I agree with that. That would be, I think, a smart tactic to take as far as your trial strategy.
Right. Because, of course, they've got to go beyond a reasonable doubt. So the burden on the state is quite significant.
It is. And I suppose you would say then, if perhaps none of these tests are reliable, maybe he didn't have any methamphetamine in his system at the time of the accident, would be, I think, the way the defense would try to frame that for the jury.
Absolutely. Absolutely. And, and that's what, people have to understand is these kind of issues come up. So many people are frustrated, whether they're a party to the case or they're just observing and think the wheels of justice are moving too slow. But they get so frustrated because it takes so long and then there's a delay. They don't understand. But things happen. I mean, when you're trying to get a case ready for trial, we're not talking about going in there. It's not like a physician that walks in and we're going to have this surgery today and you cut them open and all the parts are there. I mean, you don't have to worry about it. There's going to be two lungs, a heart, and you've got all this information and it sits there. When you're getting ready to try a case, it's a lot like herding cats because there's some information that you've been able to get and that you can rely upon, but you're still dealing with humans and you're dealing with testimony that changes or someone becomes unavailable or someone passes away or someone else has a scheduling conflict and things just happen. And it's frustrating for the lawyers as well, but the clientele and the people and the public watching this have to understand all of the various factors that can come into play that can keep a case from staying on track.
That's absolutely correct, and particularly in the context of a criminal case,
right. They don't have all the discovery that we have in a civil case. I mean, in a civil case, you may have taken 20 depositions. So if someone's unavailable, you can use their deposition to put in that proof.
Right.
Or you've got a much easier means of trying to require someone's attendance. I mean, in a criminal case, you've got, open file discovery is what any DA would tell you. But that open file discovery has nothing to do with compelling other, witnesses and third parties out there in the public buying that proceeding. And so that's where you really get caught short on the criminal side. Although I've not really done that much of it, I understand that's the real problem is trying to get cooperative witnesses out there to come in, not necessarily say what you want to say, but at least come in and testify.
Well, that's exactly the issue, according to this article, that was the cause for delay in this particular case was an out-of-state witness's unavailability to testify.
Right. So, but that's not what one of the major issues I want to talk about. What I want to talk about is something that we've seen more and more in Hamilton County and in Chattanooga, and in fact the entire area around here, and that is a violation of rights as provided by several laws, both state and federal, that has resulted in or caused by solicitors, people soliciting for legal business. And it's really unfortunate because when I started practicing, the business was still a profession. It was changing, but it was still a profession. And I remember talking to the old timers. There was one former attorney who's passed away now. I remember sitting down with him, and he was all concerned about the billable hour and how young attorneys were pushed to bill so many hours per week and per year. And he said, Jim, he says, sometimes a lawyer just has to push his chair back, lean back, and think. And you can't bill for thinking. You've got to just think and use your imagination. And that was the old professionalism that was there, and it still existed for a number of years, and it still exists with a lot of lawyers today, but it's changing. And that's one of the big issues and the problems that we're seeing is with out-of-state advertising, law firms from out of state trying to come in and garner cases out of this community. You've got lawyers from Alabama that are, associating one young attorney here in town maybe and setting up a small office and then putting up billboards. We got lawyers from Knoxville. We got lawyers from Texas that are coming in. I know that in the Woodmore case, that's really what started driving a lot of the concerns in this community is that Woodmore bus case, where there was so much solicitation activity, primarily by firms out of Texas and that area, trying to come in and trying to obtain cases of the parents for the children that were injured.
Jim, for our listening audience, when you're referencing solicitation, or are you? I think you're probably including in that definition some advertising, but are you also speaking more specifically to direct solicitation?
Right. That's, to me, there's a difference between just general advertising, putting up a billboard, having something on the radio, having something on the back of the phone book, and a solicitation where there is a direct, purposeful contact with a potential client seeking legal representation. And to me, that's where the offensive nature of a lot of what's going on has occurred. And there are laws and rules of ethics out there that are in place that are supposed to stop that from happening. For example, one of the big things is the state of trauma that a family is in immediately after an accident. Emotionally, they are not in the position to soberly reflect on what they want to do and enter into a contract. And that's what an engagement is. When you engage a lawyer, it is a contract from a business transactional standpoint. And so the bar has the Tennessee Bar Association has recognized that there's a time where family just needs to focus on healing. They need to focus on whatever their loss is. If it's the death of a child or a death of a parent, or if it's a severe injury, amputation, paralysis, whatever's happening as a result of an accident or a car crash or whatever. And they need to have a period of time where they just focus on those things. And as a result, our bar regulations prohibit solicitation of potential clients for a period of time. Isn't that right, Trevor?
That's correct. There's a 30-day, well, I guess you call it a 30-day grief period or period where an attorney is prohibited from making any direct solicitation to the victim of a car accident or injured party. Or in 30 days, I don't know necessarily. I don't know how they arrived at that particular period of time, but that's what the rules provide, is a 30-day period.
Well, what it was a balancing between the First Amendment right to the attorneys for commercial speech and their opportunity to contact and speak to people about what their wares were and what they wanted to basically sell. And that is their representation and ability to represent them. And the needs of the public, and especially of the injured individuals and families, to grieve, to heal, and to just take in what has happened to them. Because unless you've been in a horrendous accident, you have no idea what impact it can have on you and your family and your ability to consider these matters. Suddenly you've got the emotional pressures of the loss, the emotional pressures of taking care of who's left. You've got the financial pressures of unexpected medical bills. You've got the financial pressures possibly of the inability to work and how you continue to support if you got to take care of this loved one so you can't go to work. What do you do? So many things are going on in that initial time frame that no one's prepared for.
And I don't know that even after 30 days, you would necessarily have gone through entirely that process of grieving or,
Oh, absolutely
getting
not.
acclimated. But
Right.
that's
That's what I'm saying. It was a balancing. It's a balancing of interests to try to not only protect the public from unwanted and inappropriate solicitation, and to also recognize that there's a right of commercial free speech.
and that's I think a very delicate balancing.
Right. And so we got the 30 days, but that 30 days is not being honored.
No, and that's I think we are on the way over speaking specifically about this Woodmore bus accident and some of the apparent direct solicitation that occurred with some of the families whose children were injured in that horrific accident.
Right. And as a result of that, I mean, it's not just solicitation within the 30 days. And I mean, there were stories of paralegals from these law firms in Texas coming in and into hospital rooms uninvited and making direct solicitations, trying to sign someone up in the hospital.
Which, and that's, I mean, a direct in-person solicitation is even more egregious than a mailing.
Exactly. They were people who were have been holding themselves out as clergy, trying to refer. There is a continuing problem in Chattanooga and in other cities in Tennessee where there are chiropractic firms and medical clinics that are reaching out and contacting victims in accidents and offering them a medical evaluation. And when you get them in, not only signing them up for treatment, but also signing them up with a lawyer through a referral so that they can make sure that they get their medical bills paid that they're now rendering to this person. I mean, it's just horrible, nasty, yucky stuff that, I mean, it reminds me of Paul Newman in The Verdict, the movie The Verdict, where there was such terrible when he was showing up at funeral homes and lines for people he didn't even know and trying to tell the widow, how he was sorry for their loss and handing them his business card. And that's the kind of things that people in our profession hate and don't want happening. And there are rules out there that our profession is governed by, but they only work if everyone is doing them, because otherwise there are still people out there in the public that are being taken advantage of.
Well, that's right. And going back to this idea of a direct in-person solicitation, that the 30-day waiting period doesn't apply to that because those are expressly prohibited. I mean, you're never supposed, an attorney should never go himself or send his staff to directly solicit a victim. That's my understanding, at least.
Oh, and but the letters themselves. I mean, I know there was someone in our office that was in a wreck and got a letter 2 days later from a law firm. They read in the accident report where there was a wreck and that they may have a claim and that they should get back to them.
That's right, and one can only infer from that somebody at a law firm is somebody working with the police department to review accident reports, and then is using the information from the accident report to contact one of the parties who may have been injured in the accident.
Right. And so despite the 30-day prohibition, they're going forward with the letters immediately. And so, I don't know how we do that. I mean, I know that our bar, as far as an administrative agency and trying to enforce the rules, has its hands full. There are so many attorneys in the state of Tennessee. I think last count were about 25,000 lawyers in the state, and trying to govern what's not only going on with each of those attorneys and their relationships, but also trying to govern the activities of out-of-state lawyers, the advertisements that are out there. They're supposed to be vetted by the bar and confirmed. All the things that are going on. It's just more than the staff of the bar organization can handle. I understand that. but still, we've got to do something to protect the rights of the injured people, to prevent them from going through, these solicitations when they're prohibited.
Well, and that's ultimately where the focus is intended to be, is on the person who was injured in an accident or is a victim of some kind of crime or something, some traumatic event, where, particularly initially right after the accident or whatever caused the injury, they're particularly susceptible to undue influence or some type of, persuasion, where they would, if they were clear thinking, they would have a better opportunity to consider all of the facts that they need to think about before making a decision.
Right. And it happens to all of us. I mean, I had a speeding ticket in Virginia back a few years ago, and I received 5 letters from various lawyers in Virginia who I had never heard of, indicating that they were the man that could take care of my problems and for me to contact them. So we all have received these types of letters, whether it's because of a moving violation or whether it's because of a motor vehicle accident or some other tragedy. We have seen these types of solicitations, and if you have something that you'd like to share with us, we certainly have a line open to take your call. Our number here at the station here at Nooga Radio is 423-800-8949. That's 423-800-8949. And we can discuss with you the experience you've had with what you considered an inappropriate and unwanted solicitation from an attorney and how it was resolved, or how it could be resolved if you want to go further with it. I know that, there have been cases filed across the country by bar organizations against out-of-state attorneys for violation of these rules, and there have been steps taken. More recently, there has been a new attack on what solicitors are doing in the country, and that's because of accident reports and the information that is available on driver's licenses. The right of privacy is an innate right that we all have, but because of governmental requirements, we have to disclose certain information to our government to be able to enjoy certain rights, whether it be Social Security benefits and signing up for Social Security and paying into Social Security Administration, or whether it's paying your taxes, or both state and federal, or in particular, if it's getting a license to drive a motor vehicle on the roads of this state or any other state. You have to disclose certain identifying information.
That's correct.
And that information, by both federal and state law, is protected. Identifiable. I mean, it's protected in the medical field. HIPAA itself prevents your medical providers from providing identifiable information about the individual, as well as providing specific confidential information regarding their issues and treatment.
So, right, in the medical field, obviously there's a larger overarching concern of protecting patient-doctor confidentiality, and ensuring that the patient is confident he can tell his physician something without, for necessary medical treatment,
Sure,
without having the risk of it being repeated to somebody else whom he might not want to know information he's communicating with his physician. And then with the information we're talking about now, there's not an overarching confidentiality requirement between, a citizen and a governmental agency. And so Congress has come in and passed a statute essentially saying we're going to protect this consumer, what I would consider to be consumer identification.
right. Well, in this particular situation, what we're talking about now is the information on driver's licenses.
Correct.
And
right.
The statute out there is a statute relative to the private information on driver's licenses. Do you know the origination of why that came about?
I don't know this for certain. I recall in law school studying, there had been some litigation against some state DMVs who had actually been releasing information to agencies who were acquiring it for purposes of advertising to citizens of a state. And
so they were selling the information.
Correct. They were selling the information.
Let's just put it down. The state was raising money.
And that happens even with private business organizations. they take consumer information, they sell it to other people, and there's advertising directed toward those consumers. But you have a choice as to, where you engage in commerce and from whom you're going to consume goods. And you'd have the right, perhaps, not to shop there if the person is selling your private information. Almost everybody needs a driver's license. And so there's a more overarching concern of almost every citizen is going to be providing this information to a public agency, selling all this private information. Then the private citizens have no recourse. They have to have a driver's license. They can't pick and choose whether or not they're going to provide that information. So I think in response to that, Congress passed the act basically imposing these privacy restrictions so the state DMVs wouldn't continue that practice of selling this information to unrelated third parties.
Well, and you can see, your driver's license, depending on what state you're in, has your social security number on it. It's got your home address. It's got your date of birth. It's got almost everything they need that if they ever had a credit card, they could almost access your bank accounts or anything else they needed to, just based upon the data that's on a driver's license. It also has my height and weight, which totally offends me. But not only do you see what God did to me and my features in the photograph, but then you turn around and you have to deal with the fact that I'm disclosing just how big I am.
Yeah, well, the height probably isn't so bothersome. The weight, however, I understand. Yeah, I don't want to disclose the weight.
So now they know I'm both old and fat now that they've got the driver's license. So you can see why and how were made to Congress and why our federal government passed the Driver's Privacy Protection Act.
And we see this in other areas too. There's a lot of public debate, for example, about a person's browser history and whether or not these third-party providers could sell the information. And Congress recently changed the law allowing them to sell that information. And there are a lot of privacy concerns about that. So this is something that applies in this context, but also in others where there's a lot of public debate as to what needs to be in place.
Right, because we are in a information age. People are in the business of selling and exchanging information constantly. Well, I see that we're here at the half-hour break. This is Legal Bytes with Jim McCoon and Trevor Ashley, and we'll be back together with you after the news on the half hour here, and look forward to discussing further the violation of consumer privacy rights and the effort to solicit legal representation. Thank you.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM. 3, 2, 1. Chattanooga Radio. Digital FM 95.3 HD4. 92.7 FM's news now.
Chattanooga man Demetrius Buchanan has been added to the TBI's top 10 most wanted list. He's accused of first-degree murder, reckless endangerment, and employment of a firearm during the commission of a dangerous felony. The police say he has a history of drug-related charges and possession of firearms, and his whereabouts are unknown. 3 firefighters pulled an unconscious woman out of a blazing building in Lookout Valley. It happened at 3 o'clock in the morning at 111 Central Avenue. 2 men escaped the fire, and 1 woman was pulled out by firefighters. The cause of the fire is still under investigation. A small fire at Calvin Donaldson Elementary School forced the evacuation of that facility, according to firefighters. The cause of the fire? A 4th grader took off his shirt in the bathroom and set it on fire, tripping the alarms. Nobody was injured, and there was no damage to the school. Russell Stroud, Nooga Radio News Talk 92.7. Now.
Traffic, news, and information. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.
Nooga Radio News 92.7 FM's fast forecast now. 84 degrees in Chattanooga from Nooga Radio News, the home of Sean Hannity, every weekday from 3 to 6. 87 is our high today, and 66 is a low. Overcast tomorrow with a possibility of rain, 86 the high and 66 the low. And Wednesday, overcast again, possibility of rain, 86 for the high and 66 for the low. Clearing up by the end of the week to be partly cloudy. That's your fast forecast.
Tennessee Valley's news, talk, and sports leader. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.
You've been in a wreck.
756-6400.
You've been wrongfully fired.
756-6400.
A turkey is suing you out of the blue.
756-6400.
Confused about a business startup?
756-6400.
That's the number for you. 756-6400. Right here, right now, Chattanooga. Call now. Top flight legal help awaits. Get biz advice now. Representation to fight for your right. What are you waiting for? That's 756-6400. Don't sit on your rights. You've got remedies. Turn your tragedy into cash. You've got the solution from estate planning all the way to probate. Act now. Top attorneys in Chattanooga are waiting to help you get relief. Act now. No out of pocket. You don't pay a dime until we win. So win with us.
756-6400.
Call now. Top flight legal help awaits. What are you waiting for? That's 756-6400. Turn your tragedy into cash. Act now. No out of pocket. You don't pay a dime until we win. So win with us.
756-6400.
756-6400.
Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree. Call 423-800-8949. 800-8949. Nooga Radio. 92.7 FM and 95.3 HD4. News Talk Nooga Radio.
Well, this is Jim McCoon. Welcome back to Legal Bytes. I'm here with Trevor Atchley, and we've been discussing with you in the first half hour the issues regarding the violation of individual privacy and the privacy rights afforded by the states and federal government, and how that is impacted by solicitation, in fact, improper solicitation, illegal solicitation by law firms trying to garner business. And Trevor, you and I have both experienced, had some experience with what's going on, and we're also aware of what happened in Chattanooga regarding the recent Woodmore bus accident and the solicitations that occurred there. And there are a lot of things that have gone on. I mean, for example, I remember reading initially and thinking how nice that there was an artisan from Texas that was building custom coffins for the children who lost their lives in that horrible accident. And I thought, what a caring, wonderful thing, until I later found out that he wasn't volunteering or giving of his own accord, but he was actually being funded by a Texas law firm, and was sent over here to do that by a Texas law firm in the hope of being able to garner clients for their representation.
And that, I mean, that's borderline fraudulent.
Well, there has been more than just borderline fraud committed in a lot of these situations. Like I said, there have been paralegals and investigators who oppose themselves as clergy,
right,
even to get into situations where they could try to solicit and gain business. There have been people who have lied and conjured their ways into hospital rooms to try to get contracts signed for representation. So there is actual fraud that does occur. I don't disagree, and I think it's a horrible thing, and that's why lawyers in this state, especially members of the Tennessee Trial Lawyers Association, are fighting very hard to try to stop these activities and trying to protect the rights of the individuals and basically bring it in. There's a attorney in town, Jay Kinnemer, who, especially since Woodmore, has made it almost his mantra to do that. And Jay's a friend and a respected attorney in town. And Jay recently, just in the past week, filed an action here in United States District Court against the city of Chattanooga and the police department as well as certain solicitors that, and that's a term simply for the purposes of what was alleged in the lawsuit because of violations of the Driver Privacy Protection Act. And it turns out what these people were doing were they were going to the Chattanooga Police Department on a daily or quite regular, frequent basis and going through the accident reports. And based upon the data in the accident reports, were then either contacting by phone or by letter these individuals seeking representation. Or, as I said, with respect to these medical clinics or chiropractic clinics, we're contacting them offering a medical evaluation that would be done free or on the cuff, basically, to get them into the office, get them signed up, and then get them in with a lawyer that they've got a relationship with to handle the claim.
Yeah. And I mean, just to put this in context, I think there's these types of abusive behaviors go on in very many areas.
Yes.
And we're speaking specifically about attorneys and soliciting injured victims, injured parties for representation. I've seen it in other contexts as well. For example, I had in the context of a decedent's probate estate, the decedent had gone to one of these denture places and had gotten dentures and had to sign some sort of credit agreement where a third party crediting agency had paid the denture place. And then she had never gotten her dentures, and the place actually closed before she could receive any medical care, but she still owed this third party creditor. And when she died, that creditor filed a claim against her estate. And fortunately, we filed some exceptions, and the court ultimately did not allow that claim to go forward. But in my opinion, that was an abusive act. That the denture, can't remember the name of it, but it closed, and the Attorney General actually issued an opinion saying what consumers needed to do to try to protect their rights. But we see this in these different types of areas where the most, probably the neediest members of our society, the most vulnerable, are the ones who are often taken advantage of.
Right. And oftentimes, people who ordinarily aren't vulnerable become vulnerable because of an accident.
That's right.
A loss of a child, loss of a family member, significant injuries, loss of a job because of the injuries or inability to work. And suddenly someone who considered themselves very stable, their family was financially doing well, suddenly everything's turned upside down because of an accident. And suddenly between the grief, the emotion, and the loss, and the financial pressures that ensue, they are vulnerable. And that's why we have these 30-day chilling periods, the prohibition against direct solicitation, all the things that our bar organizations have in place to try to protect consumers from improper acts by attorneys who are less than scrupulous. And
so now we were talking specifically in the context of this driver's license information.
Right.
Explain to us how that this issue came to even exist, or how it came to be that Jay Kent was concerned about.
Like I said, what Jay has filed and the case that's currently pending against the city is really a result of what's been going on in other areas of the country. And there was a Supreme Court case, U.S. Supreme Court case that came down this past spring, I think it was, called Marici versus Spears. And in that case, what had happened was it comes out of South Carolina. There was a firm of attorneys that wanted to take advantage of the consumer rights under certain car dealership laws in South Carolina. And to do so, they were trying to bring basically a class action for fraudulent or unscrupulous activities by car dealerships in the state. But to get that information on who all may have acquired a car and would be a proper plaintiff for standing in that litigation, they went to the Department of Safety with a Freedom of Information request, open records request, we call it in Tennessee, and requests for that agency to turn over to them certain actually thousands of driver's license owners' information. That information was turned over to them by the Department of Safety, and then they took that information and sent out letters to all of these individuals, telling them about the claims that they intended to pursue, and asking them if they were interested to return a postcard that then enclosed with a letter. Well, several of these individuals contacted their own attorneys about getting this letter, and and they were incensed that they were contacted and that their information was available, and so an action was filed against that law firm and others with respect to a violation of the Driver's Privacy Protection Act. It went to the trial court, and the plaintiffs in that action, were claiming you're using our information for solicitation, and that is not authorized or allowed, and you can't do that. The law firm took the position that this was not a solicitation, but this was information that we were gathering for purposes of litigation, and that Section B4 of that act gives us an exclusion for the purposes of gathering information. And you can understand why the federal act has an exclusion for litigation, because in a normal case, access to, for example, a CDL, a commercial driver's license trucker, might be material. And so you would want to have access to that information and his driving record and his safety record, all the things that the federal and state governments keep up on with respect to a commercial driver. But in that situation, the plaintiffs were saying, no, this was a solicitation. You weren't getting my driver's license information for the litigation. You were getting it to solicit me to be one of your clients. Well, the trial court ruled in favor of the law firm, found that it was litigation information, and therefore it was in the B4 exception. It went to the Fourth Circuit Court of Appeals, and the Fourth Circuit affirmed, although they did find that it was a solicitation, they also found that it was laced with B4 purposes as well and for litigation, and therefore affirmed the trial court. So then the case goes to the U.S. Supreme Court, and the U.S. Supreme Court comes down that it's a solicitation that's not within any exception, and reverses and says that you can't give out this information on the driver's license unless you've got a legitimate interest as contained in the act. So that's how we got to where we are, because now with that ruling, people are taking that, the 30 days non-solicitation or stand down under our bar organization rules, and they're going after the solicitors to trying to protect the consumer and public.
So although this Supreme Court case was in the context of attorneys getting information from the DMV, it's not limited to attorneys. It would apply to anybody.
And so, basically the idea in the case that Jay Kimmer just recently filed in federal court is seeking to prohibit driver's license information from being made available, whether it be on an accident report or where it's found, from being turned over unless you have a legitimate reason as authorized by law. And that's already being done by the county. The county already requires basically a testing of your purpose in order to get it. I know down in Georgia, the Georgia State Patrol is a redacting record. So when you ask for, say, a crash report of an accident that happens in Georgia, it is redacted to remove certain identifying information. Even if you are authorized to receive it, they still do it just out of an abundance, and you have to follow up to get the redacted information after a further showing. So, I mean, there are already several state agencies in our area that are doing or taking steps to follow federal law under the privacy rights that people have. And in this situation, the city, as I understand it, has immediately contacted Jay, and they're working on trying to get a form in place similar to what the county does, where if you want an accident report or you want to review an accident report, you got to state certain specific information and represent your interests, so that you've got to show what driver, or what party to the accident you have a relationship to, what their relationship is, and why you're seeking the information and signing it. And while it will slow down and be a little bit more work for the attorneys to get this information, and it's needed information in a legitimate context, it will stop the improper solicitations and the gathering of this information without a legitimate.
When in the context, particularly of a car accident, the insurance adjuster, for example, may get copies of the police report.
Sure.
And this would he would have to provide the agency who he is, why he's getting the information. Presumably, when you sign up for insurance, you sign some type of waiver allowing them to get that type of information in the event you have a claim.
If it's not in there, it will be.
Exactly right. It will be in there. And that's all to protect essentially consumer privacy.
Right. And, again, as we said earlier, we're in an information age. Our data is a commodity to many businesses, and including the legal field. And so enforcing these laws that are in place to maintain your privacy and keep your data from being fungible and used as people see fit is essential. I mean, there are cynics out there that say that lawyers that are enforcing this are just trying to feather their own nest and trying to make sure that there's not free and open competition. But that's just not true. What these laws do is these laws protect the privacy and the rights of the individual consumers who are injured or have been affected by something that was not their choosing. And so someone has to do that. Lawyers write these laws. Lawyers are involved in the passing of these laws. Lawyers raise these issues and get these laws in place on privacy and rights. And if lawyers don't enforce these laws, then the consuming public is not protected, and these laws are unnecessary. So
that's exactly right. In this particular context, it is, there's competing, I guess, public policy objectives. One is you want the government to have open records so that if a concerned citizen wants to go in and find out what the government is doing, the citizen has the opportunity to go do that. In this context, though, we're identifying specific citizen information, names and addresses, perhaps social security number, and other types of information. And so the public policy there is we want to protect this individual citizen's information, although the report itself may be a public document. We're going to redact specific information to the individual citizen.
Right. I mean, I am all for, and I agree that government should be transparent on most levels when it comes to security and our ability to defend ourselves. I agree we ought to have some limits, but generally government should be transparent. We are the owners of the government. We are the funders of the government. And for that reason, open records, whether it be through a Freedom of Information Act or an open records request or whatever state you're in, what the law provides, you should get this information. But that does not mean that the government is a marketing arm for some other business out there, so that all the data that they've obtained on the taxpayers and on the driver's license owners and on the voters who have registered is available for some business to use for solicitation.
That's absolutely correct. And it could be even for a more nefarious purpose. I mean, we're talking about that's legitimate business interest there, but God only knows what somebody could use if they had some criminal intent or something.
Yeah, agreed. Again, if these issues have affected you or your family or your business, please give us a call. We'd love to talk about it with you on the air. Our number here is 423-800-8949. That's 423-800-8949 here at Nooga Radio, 92.7 FM. And, I think people don't understand how significant this is until it affects you. And the fact that, not only have you gone through what is a total deprivation of what you felt like when you go through an accident or you go through a loss, and you really feel open and vulnerable to then find out that your private information is being used by somebody to solicit business from you. And they're taking the private information to you as private, that you were in this horrible accident and all these things happened. And they're soliciting you for business. And it really just puts salt in the wounds a lot of times. And so, the whole purpose here is to try to protect you, the consumer, and the consuming public in general from these types of damages to a lawyer or to a medical facility or to a chiropractic organization that is making the solicitation just because you were in a wreck.
And it is interesting. At the beginning of our show, you were talking about the practice of law, being a profession and then changing over time. It is strange to talk about practicing law in the context of a consumer transaction.
Yes.
It doesn't seem like that's a typical consumer transaction, but that is indeed the way it is looked upon. And even in the medical community, many of those things are looked upon as consumer transactions. And so, although we're framing this in a sort of a context of protecting consumer information, which this does, this protecting drivers' information would protect it from any third party. But we're discussing it more specifically in the context of attorneys and direct solicitations that they have done in the past from information gleaned from these reports. But it would apply more broadly, even just to any third party who's not related to one of the parties of that accident.
And it's important to understand that, the business side of the legal profession has come about in large part because of insurance companies requiring it. Lawyers, back when I first started practicing and even when I was in law school, I remember lawyers talking about representing people, and there were no engagement letters. There were no engagement contracts. They were handshakes. They were people that would come to you, you build a relationship, and you go represent them. Well, because of malpractice claims coming down where some client says you were agreed to do something that you hadn't agreed to do, or it was beyond the scope of what you were asked to do, insurance companies who were defending lawyers said, in the future, you've got to have an engagement letter that clearly sets forth the scope of work that you are agreeing to undertake. And so engagement letters came into place. And then, when people would come see you and you tell them you just couldn't help them, and later on they'd bring an action saying you didn't do anything. Well, I never engaged to do it. So then all of a sudden insurance companies start requiring disengagement letters, so that if you get a phone call from someone and they talk to you about a case that you don't feel like is worth pursuing, or you can't pursue it, or you have a conflict and you need to refer them somewhere else, you've got to send a follow-up letter or email or some communication confirming that you're not their lawyer. So I mean, a lot of what has happened to the legal profession is not driven by the lawyers, our times, and the fact that lawyers were required to take their profession, which was more based on relationships, and bring it around to a business-oriented relationship, setting forth what I've agreed to do and what I've not agreed to do, so that the risk of malpractice could be controlled. That's really what drove a lot of the changes that you've seen come about in the legal profession since the 70s. Because I think the 70s are when we first started seeing things change.
And probably the U.S. Supreme Court decision saying that the minimum fee schedules violated federal law, that I forget the exact statute, but they, at one point in time, the local bars had minimum fee schedules, so all the attorneys would charge the same fee.
Yeah, antitrust and monopoly.
And that's what it was, right? It was antitrust statutes and then once that changed, then it became more of a competition because attorneys could charge different rates for different services.
Sure. And then it used to be lawyers never advertised, and people came to a lawyer by word of mouth referral because they saw them at the courthouse trying a case, or because they knew that they represented the bank in town and those kind of things. Well, when First Amendment allegations and violations for Amendment charges were made. I think it was a case out of Virginia that opened up advertising for the legal profession because otherwise the attorneys' rights were being deprived. That changed. So, I mean, there have been a lot of changes we've seen, but that still means that consumers have to be protected.
That's right.
This is Jim McCoon. Thank you for listening to Legal Bytes. Trevor, thank you for being with us today.
Thank you for having me.
We'll be back with you next Wednesday for another edition of Legal Bytes, where we'll talk about new topics that are approaching this community and affecting all of our lives. Thank you for listening.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio. Digital FM 95.3 HD4 and 92.7 FM.
Your marriage is over.